Hello and welcome to DMH Dallard's Private Wealth Podcast. In this series of podcasts, our experts will be discussing a wide range of issues around future and later life planning and wealth management, from making a will or creating a trust, to preparing powers of attorney and ensuring the welfare of elderly or vulnerable relatives. Our experts will explore issues surrounding the administration of estates and trusts. We'll discuss effective tax and succession planning for individuals, their families, and for family businesses. I'm Jenny Ray. I'm a partner at DMH Stallard, specialising in disputes involving wills, trusts and estates. I'm joined today by my colleague Hannah Warwicker, an associate in the private client team who specialises in will drafting, estate planning and administration of estates. We're talking today about disputes in wills and the myth of the watertight will, whether it exists. We're seeing an increasing number of probate claims being brought. In the courts, the numbers have risen from 227 in 2016 to more than double in 2022 to 488. Recent research by Today's Wills and Probate suggests that in the last 10 years, the amount of claims has increased by 140%, and in the last 5 years by 34%. And the amount of claims we see in the courts is really just the tip of the iceberg, because most claims don't reach the courts. They're dealt with out of court. In The Guardian earlier this year, they estimated that there were in fact in the region of 10,000 disputed wills every year. And in a recent report by The Times, they've suggested in the last 12 months this has increased by 20%. So, Hannah, can we do anything at the will drafting stage to prevent a claim being brought? Do you think there's any such thing as a watertight will?
Hi Jenny, first of all, hello. Just by way of background, I am now a private client solicitor at DMH Stallard. In my former role, I did deal with contentious probate cases, so I'm well aware of the types of claims that can be brought if a will is incorrectly drafted or there's undue influence or other factors, which Jenny and I will speak about later. But in terms of having a watertight will, I think that the key thing is seek professional advice. It is a legal document, so if you come and see a solicitor, they can make sure that it complies with the Wills Act, that it's properly signed, that the witnesses have signed whilst the person who's writing the will is in the room. There are certain requirements that have to be met under the Wills Act, so certain formalities. It's very important that they're complied with, and the solicitor or your legal advisor who's dealing with that can make sure that those requirements are met. So potentially, yes, there is such thing. You can do as much as possible to make it watertight. But as Jenny and I will discuss, there are claims that are unfortunately unpreventable, however much you try to make your will watertight.
So the first step is complying with the formalities of the Wills Act, making sure that it's properly drafted and executed. There are quite strict rules, aren't there, about how it's witnessed and signed?
Yeah.
And do you normally give your clients advice about who should witness the will?
Yes, you've got to make sure that they're independent and unrelated, and you don't want any of the beneficiaries being the witnesses. So any of the beneficiaries under the will to be the witnesses, because that would then invalidate their gifts. If they were to act as a witness, then it would mean that their gift would fail under the will. So you can get neighbours. A lot of the clients that I see, they like to come in because it can be quite a personal thing to people. So they like to have the confidentiality of having a solicitor and a secretary of people they don't know acting as their witnesses. Some of the queries you might have is, what happens if the person signing the will is blind? Well, as long as you've read it through to them, then they can direct that it's signed on their behalf, or you can show them where to mark it. And there are certain extra clauses that you then have to put in the will to show how it's been signed. And the witnesses also need to know that it was the testator who has signed it as well. So the testator is the person who makes the will. So if they can say, that's my signature and this is my will, and so the witnesses will either see it being signed, or the testator will say, this is my signature and this is my will, if that makes sense.
Yeah, absolutely. Okay, so you've drafted your will in accordance with the legal requirements. It's been executed, again, in accordance with legal requirements. In theory, that should be a legally valid and watertight will. But as you and I know, that's not the end of the story. So how do you go about advising people how they can reduce the risk of these types of claims? So if, for example, we take the issue of testamentary capacity first, because we often see claims where people say that, I want to challenge the will because I don't believe that the person who made it had the capacity to make a will. So do you want to just explain what we mean by testamentary capacity?
So that is the ability of the person who is making the will to understand that they're actually making their will. So prime example, we had an elderly client come in to see us, and she said that she wanted to leave her flat to a friend who she had kind of met outside the theatre. They hadn't known each other very long. And I said, well, was it your idea or was it the friend's idea? And she said, oh, it was the friend's idea just to leave my flat to her. And she was quite elderly, this lady. She was in her 80s and lives on her own, quite vulnerable. So I said, okay, I'm really concerned about this. So what I'm going to do is I'm going to get what's known as a specialist testamentary capacity report to make sure that she knew exactly what she was doing and that she had the required capacity to make a decision about what would happen to her estate when she died. So what this means is that an outside organisation who is independent to me comes in and has a meeting with the client and asks them a number of questions, and they go through what's known as the Banks and Goodfellow test, which, Jenny, I'm sure you're aware of. So they talk about whether she has an understanding of what's in her estate and that she understands the potential claims that could be made against her estate if she excluded somebody, and that she understood really what she was doing. And I think I've covered everything on Banks and Goodfellow, Jenny.
Yeah, I think that's covered it well. I think what I often see is people have a misconception about capacity, that you either do or don't have capacity, whereas it's very specific test to the actual decision that's being made at the time that it's being made. So obviously I think this is something that I see more often in claims, because we're seeing people living longer. They might be quite frail, but their circumstances will change even in later life. They may have new relationships and all sorts of different changes in their life that may mean they want to change their wills. And also people are being diagnosed at a much earlier stage with conditions like dementia. And I think there's, again, misconception that if you have dementia, you don't have capacity, whereas that's not always the case. They change over time. So,
and you can have lucid moments as well, and just think, okay, actually, I can make a decision about this at this point in time. But unfortunately, in this case, she completely didn't really have a grasp of her estate or anything. So she didn't have testamentary capacity, so we didn't change her will. But the other thing is as well, if you've got a really elderly client, or if they've got a serious illness, then the golden rule is that you should have a medical practitioner either do an assessment report or they actually act as one of the witnesses. So you can get a doctor or a nurse or any medical practitioner act as one of the witnesses as well. And that can make the will more foolproof if there are potentially concerns about capacity.
I suppose it's important for the person making the will to understand that as their legal advisor, you're not saying they don't have capacity. But you're advising that this is a good step to take to reduce the risk of anybody else saying that at a later stage.
And usually the clients understand that. And they're, if they are elderly and they're having issues with their memory or something, then they'll be happy to do it anyway. So, and I explain, look, it's going to reduce the chance of a claim in the future, and they're happy to do it on that basis.
Okay. Another type of claim that we often see is people suggesting that when the person made their will, they were being unduly influenced or in some cases coerced into changing their will by another person. Now that seems to me something that's quite difficult for a solicitor to protect against at the stage of drafting their will.
So I think in those cases, I think it's really important to take instructions from the person making the will on their own. So make sure that unless they want somebody in the room, but usually I would say, look, come into the room and give your instructions on your own and tell me in your own words what you want your will to say. And I mean, you can't foolproof against any influence, but it's whether that influence is undue or not. So how much pressure is being exerted on the person to change their will.
So we've looked at a number of steps people can take to try and reduce the risk of there being a claim, steps that people can take to make sure that their will is legally valid, that it can't be challenged on the grounds that they didn't have capacity to make the will, or to reduce the risk that it's challenged on the ground that they were under undue influence from a third party. But even in circumstances where you have a legally valid will, there are claims that can be made which don't go to whether or not the will is valid, but it's under the Inheritance Act 1975, which provides that certain categories of people are entitled to financial provision from an estate. So you could challenge the will, even if the will is perfectly valid. And it's one of the few circumstances, I think, in England and Wales where people's testamentary capacity is hindered, because usually, provided, you've got capacity, you can leave your estate however you wish. So what for you would be the sort of red flags when you're taking instructions to highlight that you need to give people advice about the potential for these Inheritance Act claims?
Okay, so if there's a potential of an Inheritance Act claim, it's usually in circumstances where a testator may be cutting out one of their children. They could have had a recent falling out and they've decided, okay, I'm going to cut out Marilyn, one of their kids. And unfortunately, Marilyn is on all kinds of benefits. She doesn't have any of her own money. She is not very well. She can't work. And so she has many needs. And I could say, okay, well, potentially, if you die, you've got an estate of £2 million. You're leaving it to two of your quite wealthy children, but you're cutting out Marilyn, who has got a lot of potential needs, and she would have a really good claim against your estate. So I would say either leave her something in the will, like a small legacy, and then what you can do is you can put in a non-contest clause. So you can say, I could speak to the testator and say, how about you leave her, I don't know, £100,000? And then the clause would say, but if you challenge this will, you won't get the £100,000. And that sometimes would deter that person from then bringing a claim against the estate. And the other thing that I would say is talk to your family about what you're intending to do. It might not always work, but if they're aware of what's coming, then they can kind of prepare themselves. Because I think that the worst thing is if they don't know that they're going to be cut out of a will, or if they're going to be less money, then it can come as a shock and people are grieving, and that's where the problems lie. But also the key thing is letter of wishes. So this is a non-binding document that goes alongside your will, and you can set out the reasons why you've made the decisions you have in your will. So this person could say, look, I had this horrific falling out with Marilyn. I know she's got these needs, but I've decided I need to leave her this amount because I believe that our relationship is too damaged for it to be repaired, and I've reflected this in my will.
So communication is key.
Definitely.
I think there's often in probate claims a lot of emotion involved, and if people have been expecting to receive an inheritance and they haven't, that can often be a trigger for bringing a claim. If it's expected and everybody's discussed it, you may be reducing the risk. And as you say, no contest or forfeiture clauses can be beneficial so that you leave somebody something. But I suppose they would need to be sufficiently generous, depending on the size of the estate or size of the potential claim, to deter somebody from pursuing a claim. And obviously, in terms of who can claim, it's quite a broad category of people. So you've got spouses, civil partners, even ex-spouses, ex-civil partners, cohabitees, as you say, children, including adult children and people who are treated as children of the family. But it also extends to anybody who's maintained financially by the testator in the period before they die.
You must have quite a few good cases under the Inheritance Act.
We see a lot of Inheritance Act claims, and I think the most common is cohabitees, where people just haven't given any thought to drafting a will. So they think that there's a concept of a common law wife, and of course there isn't in the UK at the moment. So if you die, even if you've lived with someone for 50 years as cohabitees and as a couple, that person won't automatically inherit anything under the intestacy rules. So, that's probably not what anybody wants. An Inheritance Act claim can be very useful in those circumstances. And we also see increasing number of adult children making claims. I think that's more common, particularly with young adults who tend to live with their parents for longer, and there's an expectation that they'll be maintained and supported into their 20s and even early 30s, particularly if they've got additional needs.
Yeah. And also their financial circumstances will have a massive bearing on the strength of their claim, won't it?
Absolutely.
the children. Yeah.
Absolutely. So there's lots of claims that can be made, even where a will is legally valid. So if you could summarise, Hannah, what you think the key steps people can take to reduce the risk of there being a claim in their estate.
Okay, so first and foremost, I would say come and see a solicitor, come and see us about having your will done, and get professional advice. Don't get an off-the-shelf will, because you might not do it properly. It might not be signed properly, and then it's not valid. And this is what you want to happen to your assets and how you want your estate dealt with when you've gone. So it's very important, and to have, proper control and to make sure it's done properly, get professional advice. Speak to your family about it, what you want to do. Do a letter of wishes to go with your will if necessary. And that's something that we can advise you and direct you on if you're worried about how to draft it or things like that. We can assist with that. The main thing is just get it properly done and organised, and get a will as well, because if you don't have one and you are cohabiting, or, your estate might not go where you think it's going to go. So get proper advice.
Obviously, there are significant steps that you can help people take to reduce the risk of a claim being brought in their estate, but it might not always be possible to completely prevent there being some sort of dispute or claim. So obviously, if there is a claim, I would always recommend that anybody involved in a disputed estate also seeks advice at the earliest possible stage. And I think that investment in sound legal advice when preparing your will, or as soon as a dispute arises, is always cost effective in the long term.
Yeah, definitely. It's worth spending the money professionally on getting a will done to hopefully try and prevent disputes in the future.
Thank you, Hannah, for your time today. It's been really useful insight. I hope that everyone will join us again for more in this series of private wealth podcasts. More information can be found on our website at dmhstallard.com.